All right, I think we can get started and put up the PowerPoint presentation. And I just want to do a few housekeeping items before we officially get started. First, want to just welcome everyone. I'm John Lenz, Assistant Superintendent with the Marin County Office of Education. I want to thank you so much for being here this evening. Want to also let you know this webinar is being recorded and will be available on the Marin County Office of Education website. You'll find it under the School Districts Forums or County Committee on School District Organization shortly after this event is over. Also want to thank Marta Biton, who is our interpreter this evening. My colleague Araceli Nunez will now share how to navigate to the interpretation channel to hear this presentation in Spanish. So, Araceli, please.
Bienvenidos. Este webinar se transmite simultáneamente en español. Haga clic en el botón de interpretación del idioma que aparece en su pantalla si desea escuchar esto en español. Gracias a Marta Bitón, que es nuestra intérprete esta tarde.
Thank you so much, Araceli. And tonight, wanted you to know we'll also be joined by Tarina Maris, who is our Senior Deputy Superintendent for the Marin County Office of Education. And Tarina is also the Secretary Designee for the Marin County Committee on School District Organization. So we're fortunate to have her expertise this evening, and she will be serving as our tour guide as we walk through this information. And as you know, we did receive a few questions prior to the webinar that we were able to incorporate, and we are also allowing you to submit questions throughout the presentation, and we'll do our best to answer those questions in real time as much as possible. So that's the format for this evening, and I'll give it to you now, Tarina.
Thank you, John, and thank you everyone who are joining live this evening for this webinar. And as John said, we will be recording it. And so thank you in advance to all of you who may be watching this after the fact. Let me first make sure that you can, John, can you give me a thumbs up? Are you seeing the introductory slide? Okay, very good. So as John said, I serve as the Secretary Designee to the County Committee. And I'll go into a little bit about the distinction between the role of the County Committee and I think one of the questions that may have come up is that, what is MCOE? So I'll talk about the distinction between those two bodies. And so this is our agenda for this evening. We have 1 hour. I think we can get through this in an hour, including addressing all of the questions that have come up. So let me go back for a second. The one thing I want to make sure and describe is that this webinar is really intended to be an overview of the process of a territory transfer by way of a petition. And it's not speaking to any one particular petition, although I know a lot of the interest here tonight happens to be around a particular area. The information that we will be sharing tonight is more generic and more about the statutory process. So first of all, what is the County Committee? And you're going to hear a couple of different ways that this body is referred. It's called the County Committee, it's called the SDO, it's called the CCSDO, and the County Committee on School District Organization is a mouthful. So which is why many times you'll hear people refer to it in shorthand terms. But they are essentially a separate body, they are not the Marin County Office of Education. I am an employee of the Marin County Office of Education, but I serve as the Secretary Designee, as John described. So I am staff to the County Committee. But what their role is they are the initiator, coordinator, analyst, facilitator, and arbitrator of any reorganization of school districts. They are the only body that can change a school district boundary. Can't be done by anyone else. And the only process for changing school district boundaries is the process that I will be reviewing here tonight. They respond to petitions, they conduct public hearings, they analyze the proposals and the petitions that come in. And that is essentially their process. I'm gonna wait just a second because I've got a question.
Trina, your slide deck, it's not, we're still on the first slide. Just want to make sure that that's where we're supposed to be, and it's not in presentation mode.
And then
Yes,
go back.
John, if it's, yeah, there you go.
So John, what are you seeing now?
I'm still seeing your, not the correct picture.
Okay, unshare really quickly.
Okay, give me 1 second.
Okay, it's worth the time to make sure we can present the information correctly.
How's that?
Yeah, can you hit on the top left from beginning so we can get the full picture? There you go.
Okay, cool.
Thank you, Melina.
Yeah, no problem.
Thank you, everyone. The same thing happened to me and Reed last night, so we're on a roll.
Yeah, Trina, we're still not seeing it though.
Oh.
I mean, as long as you, I don't know what you're seeing, Trina, but as long as you scroll through the slides, I don't know, we're just seeing the first slide.
Can you see the second slide now?
Yeah, we can see it now as you highlight it. It's just it's not in presenter view, but.
Oh, that's not right. Okay, let's try this. My apologies, everyone. I'm not quite sure why this is.
Trina, it wouldn't be a Zoom meeting if there wasn't technology problems, so don't worry about it.
I really couldn't tell you why. I'm going to go to what do you see now?
Hold on. It's the same thing. We might just have to live with it, Trina.
Is it the full screen or my?
It is just like if you have your slides on the left. Like
It's not in presentation mode.
Correct.
Oh, that's so
Karina,
horrible.
would it make sense for me to share and then you can
Yeah.
just tell me to? Okay, cool.
Yeah. Please do.
That was gonna be my next recommendation. That's what I was doing. I was pulling it up on my
Sorry, I just
computer,
ran.
but yeah, Melina, if you can do it, that'd be great.
Okay.
Thank you, everyone, for your patience.
No. Sorry.
No.
Now
apologies
I'm
necessary. It's
okay. So this is what we're gonna do here. Presenter view. All right, I think we got it.
yay. Save the day. Thank you so much. Okay, so go ahead and advance to the next slide. Okay. Let me make sure I am here. Yes. So what we're going to do, this is the agenda. I think I probably skipped over this. So it's good I went back anyway. The things we're going to cover is the role of the county committee, the options for initiating a territory transfer. There are a couple of different paths. This evening's webinar will include more of a focus on option 1, which is what we refer to as the 25% option. There is a second option that's option 2 that I'll cover just briefly. And then we'll review the state's conditions for territory transfers. And we're going to not verify a school district. That's a previous version, but we'll switch to the next slide, please, Melina. Okay, there we go. Okay, so the county committee, I think I reviewed this, but I'll say it again. They are basically the body that organizes and analyzes and facilitates and assesses whether something qualifies as a reorganization. I shared already that they are the only body that can change district boundaries. They're a part of the process, so they aren't the start and the end of it, but they definitely are, as I said, the initiator, the coordinator of the process. They conduct public hearings as part of the process. I'll talk a little bit about that. And they share information, and they actually, we also report up to the state board. So for petitions for transfers of territory where state approval is not required, which is what we're going to cover tonight, the county committee actually gives the final approval or disapproval, subject only to appeal. Next slide, please. So who are the county committee? The county committee is made up of 11 members, 2 from each supervisorial district in Marin County and 1 member at large. They serve 4-year terms, and they are in fact elected. They are not elected through an electoral process. They are elected through a local body called the Marin County School Boards Association. Is their one statutory role, and that School Boards Association is comprised of representatives from each of the 17 school districts and the County Office of Education. And so once a year, they meet and they vote on members of anybody that lives in Marin County can be a member of the county committee. They have to submit a letter of interest during the election period, which is typically held between October and December. And then they are elected by the Marin County School Boards Association. All of our current county committee members are current or past school board trustees. So they have a very deep understanding and appreciation for the role of a school district. Next slide, please. So this very busy flow chart is actually a very good guide. We're gonna dissect it tonight and walk through it step by step. But this is the flow chart for option 1. As I said, there are 2 paths for initiating a territory transfer to the county committee. This is what we shorthand term refer to the 25% option. And essentially it is either 25% of the registered voters in the inhabited territory must sign the petition in order for it to be considered a valid petition. And that petition is submitted to the county committee. This is also the same process for the majority of members of the governing boards of the affected territory transfer, either the sending or the receiving. It could be 2 school district governing boards. It could be multiple school district governing boards. Next slide, please. The other path that I refer to is the 10% petition, and the 10% threshold is determined by 10% of the electorate. I think this slide is, we've got an error on this slide. It is the 10% of the electorate of the entire district, the affected district, not as the previous path is 25% of the affected territory. This is 10% of the entire district. Next slide, please. We are, again, going to be talking about the 10% option. So now we're going to break down the 25% flow chart, starting from these were the boxes on the very left of the flow chart you just viewed. The first question that starts, is it inhabited or uninhabited? And essentially, our county committee, we've seen petitions come forward, territory transfer petitions that include as few as 10 parcels. Those would more than likely, but not always, there's a determination as to whether it's uninhabited or inhabited. So what's the definition of inhabited? Next slide, please. An uninhabited territory means it's a territory in which there are fewer than 12 persons that are registered to vote. So that's how small a territory transfer can be. The majority of territory transfers are inhabited. Tonight, we're going to go through the path of the inhabited territory. Next slide, please. So in order for the petition to be advanced to the county committee, it first comes into the county superintendent of schools. And the county superintendent of schools has 30 days to examine the petition and determine whether it is of sufficient signatures. And how does the county superintendent do that? The county superintendent forwards it to the elections office with a list of the petition signers to ask the elections department to verify if in fact these are valid signatures from registered voters in the affected area. And then we determine, did it meet the 25% threshold? Once it has been determined that it does make the threshold, it is simultaneously, it being the petition, is forwarded to both the county committee and the State Board of Education. Now, one of the questions that came in before the webinar was, what if there aren't enough? What if the petition comes in and it's determined that it's short of the signatures? The petition is returned to the petitioners and it has not been determined to be received by the county committee. No clock starts. So the county superintendent returns the petition, says it doesn't meet the sufficiency threshold, and then the petitioners can resubmit, which would then start the clock once it's determined that the signatures are in fact sufficient to meet the threshold. Next slide, please. So as we're moving across from left to right on the flow chart that you previously saw, you'll see there in the middle of that box, that triangle, is the county superintendent finds the petition to be sufficient. And if the answer is yes, you go down and the county submits the petition to the county committee, and the county superintendent submits the petition to the county committee and the state board. If it's no, it doesn't go forward. This is just the visual demonstration of what I just described. You're moving to the right. Let's say in this hypothetical situation, the answer is yes. And now the county committee has received the validated signatures from the county superintendent. The county committee then has 60 days to hold one or more public hearings in the affected area or anywhere in the county, but they have to at least hold one or more public hearings. There's also a notice that is provided, notification that's forwarded to LAFCO to put them on notice that there may be some boundary changes. And so what happens at a public hearing? The public hearing, before I go to the next slide, the public hearing is where the county committee hears from the petitioners. They make their case, they lay out the reasons for their petition, and that, like I said, one or more public hearings are held to hear the petitioners advance their petition. Next slide, please. Let's see my slide here. So what are the conditions and the criteria that the county committee must use in determining whether a petition meets the threshold for approval? Now we've determined that the signatures are appropriate. It's a valid petition. It now goes through the process with the public hearings that county committee has heard from the petitioners. Now the county committee has 120 days to determine whether it meets the state's 9 criteria for reorganizing district boundaries. And if you'll notice, this education code language is permissive. This is the state board's criteria that the county committee must follow. So the state board may approve proposals for the reorganization of school districts. It may seem a little confusing that it doesn't say county committee, but it is the state board's process that the county committee carries through. And they determine, with respect to the proposal and resulting school districts, that all of the 9 conditions are, and this is the important language here, substantially met. Next slide, please. Next slide. Oh, that's right. She did this. Okay, so on the first condition is the reorganized districts will be adequate in terms of number of pupils enrolled. This is a very low threshold, but it's an important one for whenever petitioners are wanting to form a new district. If it's an elementary district, it has to be no less than 901 enrolled students. And if it's a unified school district, it's 1,500 students. Next number, next click. The school districts are each organized on the basis of substantial community identity. And how is this determined? So there's a whole process for determining, is it a school that's aligned with a particular community or a different community? Is it consistent with being organized around community identity? Next one. The proposal which will result in an equitable division of property. A lot of these conditions don't feel like they are applicable to a territory transfer, but just as a background, it's the same criteria that is used, whether it's a transfer of territory of 10 parcels or a completely newly created school district. So oftentimes when the county committee goes through this process of determining whether a territory transfer meets the 9 conditions, this one in particular is like, well, you know, there's nothing really, no transfer of, no property, division of property is occurring. So how do you answer this? Well, it's still determined if there's a substantial number of students that are getting transferred to a new district. Does that warrant a division of property? And does that area include school district property, owned property? And should that follow? So this is a very nuanced. Number 1, very black and white, very straightforward. Number 3, much more nuanced. Number 2, much more nuanced. Okay, number 4, please. The reorganization will preserve each affected school district's ability to educate pupils in an integrated environment and will not promote racial or ethnic discrimination or segregation. This is a very important review by the county committee to make this determination. And there are student and community demographics that are collected and examined to make this determination. Oftentimes, not always, but sometimes there are consultants and demographers pulled in, depending on the size of the territory that's the subject of the transfer. Next slide. Any increase in costs to the state as a result of the reorganization will be insignificant and otherwise incidental. So in other words, if there's a new school district, the state wants to know, is it going to cost the state more money? And that's done through a series of calculations. Used to be revenue limit, now it's the LCFF, to determine, does this change the makeup of how these school districts are funded, and is it going to cost net result the state significant, not an insignificant amount. Number 6, please. The proposed reorganization will continue to promote sound education performance, and will not significantly disrupt the educational programs in the affected districts. So if you're moving a large number of students, the county committee will need to assess and make a determination as to the impact to both affected school districts, or if there's a territory transfer for multiple districts. So, and how does that happen? Oftentimes the affected school districts will come and present to the county committee. That is the most ideal to make the determination and to state their case as to whether they think this is an impact that they can absorb and that they are capable of either losing these numbers of students or gaining these numbers of students. Next slide, please. Number 7, any increase in school facilities costs as a result of the proposed reorganization will be insignificant and otherwise incidental. So this again affects whether there's a significant number of students getting transferred, and does the new district have to build facilities? I do know that there are questions. I want to acknowledge there are questions coming in that are may have been related to a previous slide. I promise we will get to each of the questions. If not tonight, we will be posting answers in the future. Okay, next slide, please. The proposed reorganization is primarily designed for purposes other than to significantly increase property values. Yes, this does happen. People want to live in a school district that raises their property values. So they submit a petition to change the boundaries so that they get moved over to another neighboring school district. that cannot and will not ever be the reason or the basis for an approval of a territory transfer petition. Number 9, please. The proposed reorganization will continue to promote sound fiscal management and not cause a substantial negative effect on the fiscal status of the affected district. How is this determination made? We, as staff to the county committee, we make a determination. We do an assessment of each school district's finances to determine what is the impact going to be of a territory transfer like this. And then there's one final catch-all condition, and that is any other criteria that the state may by regulation prescribe. Okay, next slide, please. Interestingly, the county committee actually has the authority to alter a petition that comes before it, so long as it is within the education code sections that govern this process. Next slide, please. So the approval process. If all of the conditions of the previous 9 conditions that I just described are substantially met, the county committee may, this is the operative word, may approve or disapprove the petition to transfer the territory. They have, as I said earlier, they have 120 days to do that from the first public hearing, or within 120 days of complying with CEQA if the territory transfer is large enough or impactful enough that warrants a CEQA determination. So what does that mean, may? So essentially what can happen is the county committee can determine that each of the 9 criteria have been substantially met, and they can still deny. That's the permissive authority that they are actually provided through the education code. And I've seen this happen, and when it happens, it's because oftentimes they hear from both school districts and they say, look, we don't want this. Or one school district will say, we don't want this, and they make a compelling case. And even though each of the 9 criteria may have been met, the county committee can take, just like a courtroom, they can just basically take into consideration all the information that has come before it to determine, actually, we're not going to approve it for whatever reasons that has compelled them to make that decision. So it's a permissive allowance. Next slide, please. So let's say hypothetically the county committee does approve the petition. What next? So in this scenario, again, we're in flowchart A, option 1, 25%. We've already determined this hypothetical situation that the proposed territory is inhabited. So if you'll go from left to right, the next question that is asked to determine the electorate area is the assessed value less than 10% of the original district? So you've got a subsection of a district moving from District A to District B. Is the assessed value of that affected area less than 10% of the entire district that it was a part of? And if the answer is yes, it's less than, there is an expedited process for petitioners that happen to be, maybe it's 2 school districts that say, we want to do this. So if both school districts are in agreement, they consent to the petition, either they are the initiators of the petition or they're in agreement with the petitioners. If the answer is yes, there's no election called. If the answer is no, all boards do not consent, then it goes to an election. Next slide, please. What is the election process? If the county committee finds that the conditions enumerated in the Education Code 35753, the 9 conditions, are substantially met, and either it's uninhabited or inhabited, let's go to number 2, it's inhabited, and it's less than 10%, then there's no vote. Next slide, please. However, the voting default area for a territory transfer is only the affected area of the petition. So if it is So that just imagine there's a section of a school district that's being petitioned to move from District A to District B. By the default is it's only that affected area that votes. However, the county committee could change it. They have the authority to say that may be the default. And if they make no decision on the election area, that is the election area. And then once they make that determination, it's the county superintendent who calls the election according to what the county committee has determined. If they, by choice, make an action to change the election area, then they could change it to all of one district, or they could change it to so that it's both districts. That sits under the authority of the county committee, but the default is just the area that's affected by the territory transfer. Next slide, please. So what happens if the county committee approves this, makes its determination for an election process, and the county superintendent then has to call for the election? It can be appealed, and the appeal process goes to the state board. So it can be appealed only by either the chief petitioners or one or more of the affected school districts. So a citizen itself cannot appeal the decision of the county committee. However, the appeal is limited to the issues of non-compliance. And what non-compliance? Non-compliance when considering the 9 criteria. If an appeal is made, however, on the issue of whether the proposed territory transfer will adversely affect the racial or ethnic integration of the school districts affected, it shall be made according to the education code that specifies that. So there is one exception to the grounds for appeal, and that is racial or ethnic integration. Next slide, please. Okay, we have received, I would say, a series of questions, and we have compiled them into some categories, and we'll say that really some themes. Some of these, I'll just say, are answerable. Some are not, but I will do my best to respond to each of the questions that we have identified. So first, we have a category of process. We have received a series of questions on the process. So there were a lot of questions that said, what can we do to prevent the petition process from happening? Well, there's nothing you can do, unfortunately. If you don't want the petition process to happen, you can't stop it. There's a path that the education code provides that so long as there are 25% of the affected area signatures gained and gathered and they're valid, the petition is considered valid and will go forward. If the signatures aren't, that's what stops it. Is it within Ed Code to move through the petition process with the intent to transfer from one district to a choice between 2 districts? So this is a very important question, and we're hearing this a lot right now. And the answer is, this process has nothing to do with choice. This is a very clear process that involves school district boundaries and the conditions that must be met in order for school district boundaries to change. School choice is about interdistrict transfers, or there could be an independent, separate agreement between 2 districts or more, where they work out an attendance agreement between them that has nothing to do with the territory transfer process. Next question. These are questions on logistics. What is the timing of the petition process? We did go over it. It is once the petition is received by the county superintendent, she or he has 30 days to determine the validity of those signatures. And then once that's done, within 60 days, the county committee must hold its first public hearing. Then within 120 days, and actually, Melina, let's see, I'm gonna go back here to make sure I get this right. I've got it. Yeah, it has to hold a public hearing within 60 days. And after it holds its public hearing, or it's still within 120 days from the first public hearing, it could have multiple public hearings. But from the first public hearing, it has 120 days to make its determination as to whether it has the petition has substantially met the criteria and whether the county committee chooses to approve it. And then once that happens, there's a whole chain of events around whether or not it goes to an election. And that is dependent upon where that determination falls in terms of an election cycle. And it also is dependent upon whether it's under appeal. So that's where, it's a pretty crisp timeline up until and through the 120-day review by the county committee. Once that threshold is passed, then it's very dependent upon external either entities, whether it's the state board under appeal or the elections cycle. Who is involved and how? In other words, what role does MCOE, the district superintendents, and the school boards play? So I'll answer the first one. The Marin County Office of Education has no role in this. The Marin County Superintendent has one role, and that is to determine the sufficiency of signatures on a petition. That is it. Everything else rests within the authority of the county committee. District superintendents and school boards may be the initiator of a petition. So in that regard, they would have the rights of a petitioner. They also have a role in presenting before the county committee during the public hearings to make sure that they weigh in on the county committee's decision as to whether they are in favor of this petition or they are not in favor of the petition. They also have a role if they are in agreement with the other board or boards on a petition. They actually have the authority to weigh in and circumvent the election process if both boards allow or are in agreement with the territory transfer petition. They don't have to go to an election. That was an education code that was added about maybe 10 years ago, because there were school districts throughout the state, not a lot, but a few, that really wanted to consolidate. Maybe they were small and they wanted to consolidate with their neighbors, but it was such a long process and the election process is expensive. So a school district gets a bill when they have any kind of ballot on during the election, an election. So they were trying to say, hey, if we're in agreement, everybody wants this consolidation or this unification or whatever the case may be, or this territory transfer, why do we have to go to an election process if both boards represented by an duly elected are in agreement? So those are the sort of extenuating conditions or roles that a school board may play. Why can't MCOE be more directive? I think this is specifically, obviously, in relationship to the pending petition between the Reed and the Larkspur Corte Madera School District. We as a county office, we assist and support and will aid in any way in discussions, but we don't have the kind of authority over school district boards. Those are board decisions. Is each district school board the final decision maker? They are the final decision maker into any side memorandum of understanding that they may enter into with other districts, but they are not the final decision makers when it comes to a territory transfer. That rests solely with the County Committee on School District Organization. Next slide, please. These are questions we received on duration. Is there a way to assure existing families can complete their K-8 education in Reed? This is not a territory transfer related question, so unfortunately I won't be able to provide an answer to that. This would be a question that would be more in relationship to any kind of side agreement between the two districts outside of the territory transfer process. Can you provide ways to help us maintain our neighborhood community cohesion? This is a very great question, and unfortunately, outside the role of a county committee and outside the role of the Marin County Office of Education, other than to encourage, I think, great collaboration among community members and neighbors through a variety of different outreach methods is always good and encouraged. Where there are disagreements within a community about the right path forward, I think a community forum is always good. If there's a place and a way you can, as community members in a neighborhood, you can put something like that together in a community space in your area would be the best. And then listen and problem solve together. What is it that you're trying to accomplish? Or what is it that you're trying to solve? And that would be, I think, the best way to answer that question. Next slide, please. Questions on the petition itself. We have currently well over the 25% needed for the petition. If, however, enough signatures are ruled invalid to drop below the 25%, can we, A, remedy any signatures that are ruled incorrect for unclear address or a signature not matching, or B, get more signatures to submit a valid petition? So I addressed this earlier, and I'm happy to address it again. If the petition comes forward, the county superintendent is under obligation within 30 days to verify signatures. We forward that petition to the county elections department. They get back to us within that specified period of time, and they say, in this situation, I think let's just answer. The answer is no. There aren't sufficient signatures to meet the 25% threshold, in which case the county superintendent would return the petition and say, it's not a valid petition. The petitioners would then have the opportunity to try again and get the number of signatures, and the whole process would start over. And until the county superintendent determines sufficiency of expenditures, there isn't a valid petition to move and submit to the county committee, and the clock does not begin. How can parents participate in the process? When can we engage the district? I'll take the first part of this. How can parents participate in the process? You can attend board meetings early on, but for the county committee, these are public hearings. Anyone is welcome. And like I said, with territory transfers, the county committee will hold the public hearing, at least one, in the affected area. And so it would either be in this situation, if there's a petition that comes forward involving the Reed and the Larkspur Corte Madera School District. I can tell you we had a territory transfer probably about 6 years ago, maybe. And the county committee chose to hold 2 public hearings, one in each of the respective school districts, so that parents could attend a public hearing in their own community. And in terms of engaging the district, I think writing a letter to your school board, attending board meetings is always the best way. Next slide, please. These were not necessarily questions, but we wanted to validate them by putting them and including them in tonight's webinar. These were student sense of belonging concerns. Moving students to a new school and community will affect their sense of belonging, which will be especially hard after the last 2 pandemic school years. I'm going to read them all, and then I'm just going to address them in general. Timing concern. Student was in Cove, will be moved to Reed, but a petition or interdistrict transfer is approved. Then the student is moved back to Cove. Concerned about the student's well-being if forced to change communities multiple times. Interdistrict attendance agreements have behavior contracts, but if students are made to go back to Reed, the kids need to be treated as part of the community, not as a transfer who was granted the privilege to go there, contingent on grades, behavior, attendance, etc. So all of these questions are related to issues outside of the territory transfer process. Once a territory transfer is initiated and granted, and it goes forward, there is a new school district set of boundaries between one or more school districts. So there isn't a back and forth of students. Once a territory transfers to a new school district, that is the district of residence. That is the assigned district for that territory that had been transferred. And so they have all the rights and privileges of anyone else in that district because now they are part of that district. These questions feel to me more a part of interdistrict transfer agreements and any kind of side agreement and memorandums of understanding between one or more school districts, two or more school districts who work out attendance agreements between them. And so these are very valid questions and very important to make sure any school district that's entertaining an agreement are aware of. Next slide, please. So we're going to take some additional, John, if you could let me know if we have enough time to read and respond to the additional questions that have come in.
Oh yeah, we have some time. We have some questions in the Q&A if you want to pull that up for your reading.
Okay. Does the county superintendent also verify the validity of the petitions, such as in the case where the signatures may have been fraudulently obtained? So the process of validating the signatures is very explicit in code. The only authority the county superintendent has is to determine the sufficiency of signatures, not the validity of whether they were fraudulently obtained. That information could come forward through the public hearing process.
That's a nice segue into the next question, Tarina.
Yes. Yes, at the public hearings, will other electors in the district who do not support the petition have a chance to make their case? Absolutely. These are public hearings. It's not just the petitioner and the districts that the county committee will hear from. This is anyone and everyone from the public who has an interest in this petition process. And if I will say, the county committee of 11 people, they're extraordinarily thoughtful, considerate, and they have 60 days to hold the first public hearing, and they have 120 days to consider the merits of the petition. They will hold, as the code provides and prescribes, one or more public hearings. There's a lot of interest in this. They will definitely hold more than one public hearing. And my sense is they would be sensitive to making sure all voices were heard. Is there any early read on whether these 9 criteria would be substantially met? Very good question. And I would say too soon to tell. So this is why the county committee is given by code 120 days to consider whether they are substantially met. And I would not in any way want to get ahead of that process on behalf of the county committee. Next question, do they have to give a judgment with explanation? They do not, but they always do. So there is, with 11 members, you can imagine there are 11 thoughtful, considerate committee members who understand, like I said, it's not a requirement to be on the county committee, but our current constitution of our county committee consists entirely of current and previous school board trustees. I think we also have we have a College of Marin trustee on there as well. So yes, and again, the appeal process has to be one that is determined by, you just can't do pursue an appeal unless, and the state board's not going to overturn a decision by the county committee unless it's non-compliance based. Does the county committee have to give a judgment? Oh, I already read that, sorry. Have there been other efforts to redistrict the East Corte Madera Hillside neighborhood, which is currently part of Reed School District? If so, why wasn't it successful? So I've been the secretary designee to the county committee for the past 10 years. Even though there was a territory transfer involving the two districts, it was actually in the reverse. It was down Paradise Drive. It was trying to move 10 parcels from the Larkspur Corte Madera School District to the Reed. That petition did not pass. Even though, if memory serves me correct, it did meet the substantially met criteria of all 9, but the county committee did not, and primarily because of the testimony that it heard from both school districts. Can the petitioners drop the petition at any time as it is moving through the process? Very good question, and I would have to, and I would, my guess would be yes, and I wouldn't want to guess on this. We would want to consult counsel on that question. Is it assumed that the signatures on the petition understand that a successful transfer does not mean school choice, but rather the transfer of one district to another district? Also, is it correct that the districts have an opportunity to present to the committee once the petition is verified and we reach that step? I'll answer the last one first, and the answer is yes. The districts absolutely, it's essential that they present their position on any kind of territory transfer that involves their district. The county committee would ask for it. The first question, is it assumed that the signatures understand that that a successful transfer does not mean school choice? I don't know what the signers understand, and I wouldn't be able to answer that. But it would be one that through the petition public hearings, it could be information that is brought before the county committee as an public information item. But it is definitely one that we're hearing a lot of confusion from the community as to whether or not signing a petition means you get to choose which school district, and that is not the case. The only thing that would determine whether or not there is a choice is if two or more school districts reached an agreement that allowed for student choice.
Trina, just checking the time, you have about 8 minutes left.
Okay, thank you. It is my understanding that the people asking for petition signatures verbally communicated that the petition was intended to have the East Corte Madera residents to have a choice between the two districts. Does the committee consider the context that people may have signed the petition under false pretenses? Again, that's all information that I would expect would come out during the public hearing. But once we receive a petition and it's been determined to be sufficient in terms of signatures, the county committee is not going to reject the petition because there's a charge or an accusation that the signatures have been gained under false pretenses, as this question specifies. Will the public hearings occur in the next 60 days, i.e. over the summer holidays? Depends on the date in which the signatures have been determined sufficient. That's when the clock starts. Once the petition is received, 30 days to determine sufficiency of signatures. Once that is determined, then 60 days for the first public hearing. That's a statutory requirement. So it's not that the county committee has a choice to say, let's wait until the summer before we hold a public hearing. That's an externally mandated requirement. If so, does the committee take into consideration that this petition appears to have been filed at a time when families are less likely to be around, and many families, well, in all fairness, it is June. We don't have a petition. So right there we have the soonest it could go to I shouldn't say soonest. Let's say hypothetically we get a petition tomorrow on June 16th. I can tell you, having done this before, it takes at least 30 days to verify the sufficiency of signatures. So let's just say, for hypothetical purposes, we go out 30 days from tomorrow, June 16th. Now we're July 16th. The county committee holds a public hearing within 60 days. We're no longer in the summer. We are in September. Will the public hearing occur in the next 60 days? I just read that. Can a second petition with 25 to 30% of the residents be submitted to stay in the same district? What happens if both petitions are valid? There is no such thing as a petition to stay in your district. There's only a petition to move a territory. You can get creative. You can certainly gather a petition that says, you gather a number of signatures that says you don't want it. You could present that. That's not a legal requirement or a legal consideration for the county committee to use as a factor. It could use it to influence its decision, but it's not a factor as set in code. Can people redact their signature? And I think this maybe means I signed and now I want to take my signature back. I would think that they would contact the chief petitioners and ask that their signature be removed. Will the details of the petition and the signatures be available to the public? Yes, it is a public document. If we are forced to go to the Corte Madera schools against our will, we will need to enact the transfer process immediately to ensure our second child goes to Del Mar, where our oldest is attending. What is the typical likely outcome of the transfer succeeding? I wouldn't be able to say what the likelihood of the transfer succeeding is, having not seen the petition and not gone through the process. These are all very understandable concerns and all very necessary to be brought out during the public hearing process. What is the benefit to the Corte Madera school to redistrict more pupils into their district? What would be the loss to the Reed School District? Those are, again, I wouldn't be able to answer that question from where I sit right now, but these are the types of questions that will be answered through the evaluation of the petition itself. So one of the criteria, if you'll recall, is how does it affect both school districts in terms of finances? Are they still going to be fiscally sound? This is a question we will address through the review of the petition when meeting the 9 criteria. Is it possible that some streets are approved to be transferred, but others not? Not all streets over here are listed in the MOU. So this is not the MOU. This is the territory transfer would have to enumerate the specific addresses that are included in the proposed territory transfer. If it's not included in the territory transfer, it's not effective. Now, the county committee, again, has the authority to alter a petition. So they could take a look and say, hey, we see this, maybe it's a different configuration. That's very unlikely. It's not something the county committee really gets into. They typically look at just what is being presented to them and determine yes or no, whether they approve or they disapprove. But I think it is important to note that the county committee has the authority to revise the parameters of a petition so long as they are consistent with the education code that outlines this process. Where can we access this petition so we can read it? We don't have it yet, so we wouldn't be able to provide it. And once it is received, it'll become a public record and we would be able to share it. If all goes smoothly as outlined in the process, approximately how quickly would students be required to switch schools? And if the redistricting is approved, can individual families request their children attending Reed? Again, this is The choice piece, whether it's an interdistrict transfer agreement or an agreement between two districts, is outside of the territory petition, the territory transfer process. So those are questions that would not be entertained and are outside the authority of the county committee. Is it possible for children who have been attending Reed to be grandfathered into and able to stay in the district if this petition is approved? The answer would be, on its face, no, unless there is a subsequent agreement between the two school districts that allow for that exchange of attendance and choice between the two districts. And we have reached the end of our questions, and we are right at the end of our so Melina, would you stop sharing? Thank you. Oh, one more came in. Oh, no, I read them all. John, did I miss any?
No, you got them all. Okay.
Thank you again, everyone. As John described at the beginning, this webinar will be posted to our website, I believe, tomorrow. So it can be accessed. And there's also a wealth of information on their county committee website, including all the legal details and the flow charts that I described. And there's a county committee handbook that talks about all of these, and it's chapter 5 if you want to get into the details. And with that, thank you very much, and I wish a wonderful evening to you all. Good night.